with a notice must be placed on the notice board. Never happened, Lord, but with all due respect, particularly in the light of the Lordship Relationship judgment, that notice would have been even further removed from anything else. The likelihood of anybody entering those premises and looking at that notice board is so remote. But for the rest, the publication actually went further. From memory, I think the publication was also in a circulated Sunday newspaper, the Sunday Times, and 2 local newspapers. So publication went further than it was required in sub-regulation 3, which stated that it's circulating in a local or national newspaper, circulating, etc., etc. Our submission is that, to a large extent, the judgment will create uncertainty because there is no certainty as to exactly what the consultative process entails. I know your Lordship and Relationship identified certain aspects,
yes.
But is it required? Are those exhaustive, or are they non-exhaustive lists? And absent, of course, a declarator that the regulation itself is unconstitutional because it doesn't cater sufficiently for the consultative process, we submit that another court may review the entire situation. And of course, lastly, there's the question of remedy in terms of the Constitution as to exactly what should happen, and we submit that another court may very well come to a different conclusion.
What does the regulation say about the newspapers?
It says, my Lord, that
how many?
Advertisement in a local or national newspaper circulating in the area where the land offshore area in which the application relates to is situated. And we know that.
So what area are we concerned about here? What area are we talking about?
Geographically, what you and I, the Lord, would refer to as the East Coast of the Eastern Cape. And
are there communities that are affected or that were affected?
Well, there are communities, Lord, because it's an area that's inhabited by various communities.
And those communities, in fact, are applicants in this matter?
Yes, Lord, they are.
Yes.
Some of the applicants.
Yes.
Sorry, Mr. Gqeberha, just want to understand Impact or Shell, as they did in this matter, decided that in order for us to be able to reach the communities, we are going to use a mechanism that is that of consulting the monarchs. Now, if they were embarking on that process as part of their consultative process, if they did not see to it that that process which they embarked upon actually resulted in the communities being properly informed, would you still say that still there was substantial compliance with the regulation?
The problem, my lady, is that the regulation doesn't contain what I would refer to as the real meat to the bone. I think that's where the issue lies.
No, I understand that. The regulation doesn't say consult with the monarchs. But what I'm saying is, if the regulation doesn't have it, and the party that's supposed to comply make sure that the communities that are affected get to know about it, they decide that the process that we're going to follow is that which we're going to go through the monarchs. And when the monarchs told them that we've got to tell the communities about this, they decided to leave it at that. Would you still argue that the consultative process itself was complete?
May I answer in 2 ways? The first one is that's really for those respondents who dealt with the consultative process to deal with. But secondly, on the narrow interpretation of the regulation, the department only has to satisfy itself that there's been compliance with the provisions of the regulation. Of course, there can be very other permutations. There could be other communities. One can't pick and choose the community and say, well, I didn't consult with this community, therefore there was improper consultative process. I think the ultimate issue is whether, broadly speaking, sufficient publication was made available so that people could object if they so were advised or desired to do so.
Maybe the best answer is the one that says, let those respondents that have to deal with that, deal with it.
Yes.
But the point of substance, as posed by my sister, is that they chose a particular course to engage monarchs for an important reason. But then they went halfway,
Yes.
which is the problem.
Well, it's a bit unfair on the minister. The minister didn't choose.
Yes,
choose that.
no, that's fine. Maybe my sister thought that you could be of assistance, but you've answered the
I can
question.
only be of assistance to the extent that I don't want to use the word Gqeberha view, but I think
Yes.
the minister just took the view that there was compliance.
Yes.
And was satisfied that there was sufficient compliance.
Thank you.
My Lord and my Lady, we therefore submit that leave to appeal should be granted to the SCA, both in respect of the application for leave and the cross appeal. Of course, as your Lordship has pointed out, the cross appeal will only be of importance to the minister should there be a different finding on the question of the consultative process.
Yes.
As the court will.
Thank you. Yes, who's next? Yes. Yes.
My Lord, my Lady,
Yes.
the court will be aware that in advance of today's hearing, the parties have reached an agreement, effectively that both the appeal and the cross-appeal raise issues of public importance, and that everybody agreed essentially that leave to appeal should be granted. Now, I accept that this court will want to apply its own mind to the issue and won't necessarily want to act as a rubber stamp.
Yeah.
But our respectful submission is that the fact that the parties agreed on that is something which should be taken into consideration by the court,
Yes.
and should serve as at least a weighty piece of evidence to suggest that this is a case where it would be appropriate to grant leave to appeal. So I just mentioned that as a starting point.
Yes.
In preparing for today's argument, because of that agreement, I hadn't intended to focus on each and every aspect of the application. I did want to just point one thing out, and I would hope that in a way it's been overtaken by the agreement that was reached. But you would remember, my Lord, that the 8th and 9th applicants, in their heads of argument, took the point that in order to succeed, because appeals are against orders and not against the reasoning judgment, in order for any of the applicants for leave to appeal to succeed on appeal, all of the court's findings would have to be overturned in essence, because any one of the court's findings upholding the review is enough for the order which the court granted. So in other words, his reasoning was we would have to persuade an appeal court that all of those decisions were wrong in order to set aside the order on review, or the court order that made on review. I just want to point out that although my class has although Shell, in its heads of argument in this application for leave to appeal, has only emphasized certain points. In our application for leave to appeal, in other words, the original application which launched the proceedings here today, all of the court's findings were dealt with in an application for leave to appeal in respect of all of them. So with respect, the point doesn't assist the 8th and 9th applicants because we do seek to persuade the court to grant leave to appeal on everything. But as I say, our hope is that a lot of that dispute has been taken care of by the agreement which was reached. Just on the question of consultation, again, I understand the parties to be in agreement that at the very least it raises a question of public importance. Our respectful submission is that it does. There have been a few high-profile decisions of the High Court, all in similar contexts to this one, two in relation to seismic surveys, one in relation to some other form of development, which raised this issue of consultation. And our respectful submission is that it would be of assistance to the general business community and to the general communities that are affected by these issues to have guidance from the Supreme Court of Appeal
on the issues that are raised here. We respectfully also submit that there are prospects of success on the issue of consultation. I don't want to repeat what my learned friend said for the Minister, but of course he did make the fair point that when it comes to issues of consultation, it's really Shell and Impact that are the parties that took responsibility for the process, not the Minister. And so I would just like to address the questions that the bench posed very briefly on this issue about the monarchy and about incomplete consultation.
Yes, please do.
My Lord, you will appreciate in our heads of argument, the focus that we placed in our argument was on Regulation 3. And our respectful submission that there was substantial compliance with Regulation 3. And the court will be aware, because we also argued this point in the main application on the merits. It's the same argument. Our argument is in substance that in order to get where the applicants have reached on the point of consultation now, they ought to have challenged Regulation 3 as unconstitutional and sought to have it set aside. And our submission is that in the absence of having challenged that regulation, they couldn't succeed in persuading this court, or they shouldn't have succeeded in persuading this court that there was inadequate consultation. And our submission really is
that it is unfair to effectively retrospectively impose obligations on Shell or was Impact at the time of the conducted the process.
It's not fair or appropriate to retrospectively impose obligations which didn't exist at the time. So in other words, what we are effectively saying is that although you substantially complied with Regulation 3, looking at it now through the benefit of hindsight, there were aspects of the process which were inadequate. We say the way to get there would have been to challenge Regulation 3. So,
or rather that the SCA will take a different view to what this, to the view that this court took. And so we respectfully submit we do have prospects of success on that point. But as I say, even if the court is not with us on prospects of success, when it comes to consultation, our submission is that it engages clearly a question of important public interest, and that for the purpose of certainty and the purpose of everyone knowing where everybody stands on this issue, it would be in the public interest to grant leave on that issue.
And I would imagine if then it's of public importance, it also means that when one embarks on a particular process, one must see to it that that process is followed through and properly, otherwise it becomes a sham.
My lady, with respect, we're speaking at cross purposes. That goes to the merits of whether on this court, in other words, the full court's view on what was appropriate consultation. It goes to the question of whether there was full compliance with that. So in other words, the full court takes the view that there had to be substantive engagement with the communities on the ground, that there was not sufficient, it was not sufficient simply to engage the monarchs, and the court also takes the view that on the facts, it's established that the monarchs themselves said you should go and consult directly with the communities, and so the full court then takes a view that there was inadequate consultation. Our response to that is to say, with respect, we take issue with the finding that on the facts, that's what happened. But even if the court is against us on that, the fact of the matter is we still stand by the fact that as a matter of compliance, all that was necessary was compliance with Regulation 3. So even if a party decided to try and go further, and for reasons on the facts which we're not sure about, that process wasn't complete, it still doesn't invalidate the process because there was substantive compliance with Regulation 3. And again, I do wish to emphasize, even if reasonable people can disagree on this proposition, we submit that it's at least a debatable proposition, and at least that there are prospects that another court would disagree. We can put it no higher than that. We obviously are aware that this court takes a different view.
I don't think I don't think it should end at merely saying it's debatable. I think the wording of the section takes it a bit further, but I'm not going to go into the wording of the section. Is it of any significance that when you reach out to communities, you should use a language that they are afraid of?
Well, again, with respect, my Lord, the attractiveness of the proposition at the level of principle, that if you are going to engage with people, you must engage with them in a language that they understand. is self-evident. It would be foolish for me to try and argue against that proposition at the level of principle. So the only submission I would make on that point goes back again, and this is why we keep emphasizing Regulation 3, is that on the way Regulation 3 was framed at the time, the publication in English and Afrikaans was sufficient. Now, whether or not that has the substantive effect of reaching the African communities, we can't submit that they're wrong when they say it did.
Upon a reading of the very regulation, I believe one could have used Xhosa and English for that matter.
Yes. With respect, certainly so.
Yes.
So it could never be argued that a person or an entity that chose advertising English and Xhosa would be non-compliant. But we're just simply saying that at the time, for whatever reason, the decision was made to do it in English and Afrikaans. It might not have been the ideal decision to have made, but it's accommodated within what was required by the regulation. And so one cannot say that it was non-compliant, even if one could say that the alternative would clearly have been compliant. And again, we simply say that there's reasonable prospects that another court would agree with us on this. As your Lordship knows, it's always awkward when one is addressing the very court that already reached the decision on this point. I am not attempting to be obsequious when I say that there is merit in the approach that the full court took. We're simply saying, though, that we do believe that with respect there is the counter-argument based on Regulation 3, and we do believe that there are reasonable prospects of success. But again, I would keep coming back to the fact that ultimately the court does not have to go so far as to find that there's reasonable prospects on that, because the public interest point would be sufficient to justify granting leave on consultation. My Lord, my Lady, just on the question of delay, there's 2 points I wish to make there. The one, just briefly on the merits of the delay point, we're obviously again mindful of what the full court held. We would simply say that there are reasonable prospects of success on the delay point because, number one, another court on the similar facts, that's the single judgment of Gqeberha, who was acting at the time, he's now Gqeberha, found that the May 2020 notice was sufficient to put the public on notice about the administrative action in question, and therefore he said in an arbiter statement, admittedly, but he said in an arbiter statement that the review would have delay difficulties. So, of course, that immediately shows that there are differences of opinion on this point from the bench in the same or similar factual context. So we would say that our arguments...
There's a full court judgment by this court, which is the subject of today's hearing. And then there's a judgment by a single judge in this division. Is that of significance?
Well,
accepting that, because somebody may argue that that is not how the matter was argued before coming to AJ as it was. Certainly not on the facts.
Well, with respect, there's 2 issues raised by your question, my Lord. The one just about the single judge versus the full bench, the full court. Of course, the full court's decision will now trump this decision, but I just raise it as evidence that reasonable people can disagree on the point, which is relevant to the question of prospects. Because if the SCA is of a similar mind to Judge Gqeberha, it might be willing to revisit the issue or to take a view that's different to the full court. But there was reliance placed in the proceedings before him on the May 2020 notice. And this court was not impressed by the May 2020 notice when it came to the delay issue and to putting the public on notice. But we just simply make the point that he was, and that it does demonstrate that there is at least a prospect of persuading the appeal court that May 2020 notice on the e-tolls case, the outer case of the SCA, on the basis of the test established there, it did give the public at large sufficient notice. But then also the court will recall that that my client Shell took the point that one of the applicants on his own version knew about the administrative action at least a year, I think it was about 8 months rather, before the application was lodged. And so we used that as relevant to the delay point. Again, this court was obviously not impressed by that point, but we would submit that there are prospects on appeal on that issue. But my lord, my lady, there's a bigger issue when it comes to delay, and this would also be relevant to internal remedies and some of the other, let's call them, maybe less prominent from a public interest point of view points. Our respectful submission is that if this court is minded to grant leave to appeal, it would not be appropriate to then go through an exercise of trying to carve out the case and granting leave to appeal on some points and not on other points. Of course, it's open to the court to do that. But my respectful submission is that once the parties have reached agreement that everything raises public interest considerations, and once, and I'm being presumptuous, I'm just for the sake of argument, assuming that the court will be willing to grant leave to appeal in some respect.
And bearing in mind that the court may not be bound by the agreement.
Yes, absolutely. With respect, the court is not bound by the agreement, and the court may go away and decide that there's not granting leave on anything. But I'm assuming for the purposes of this leg of my argument that the court will be with us that at least some of the issues raise issues in the public interest and will be minded to grant leave in respect of at least some of the issues. Then our respectful submission is that it would be appropriate to not try and then limit the appeal to certain issues and to rather allow all the issues to be ventilated in the SCA. And the only reason I say that is with respect to practical consideration. In the normal course, the gatekeeping function of leaves to appeal are very important because obviously this court or any high court is supposed to prevent the SCA or even full courts in those cases of being clogged up with unmeritorious appeals. So obviously it's important to have an application for leave to appeal. But once you're granting leave to appeal on issues of this high prominence, our respectful submission is it would be inappropriate to handcuff the SCA on the issues that it can determine when it comes to this case. So in other words, if this court were to grant leave to appeal on let's call them the big issues, the consultation, the statutory interpretation points, the points which clearly raise public interest considerations, it might be that the SCA takes the view that the delay point is dispositive. This court may not think so because, of course, this court is not particularly impressed by the delay point. But it might be that the SCA looks at the case as a whole and says, you know, actually this is a case which raises a cut-through point. The delay point is dispositive. So we would suggest, with respect, that it would be appropriate to give the SCA the freedom to apply its mind in that way, and rather just allow the SCA to consider all the issues. If the SCA takes the view, just like this full court did, that the delay point is not meritorious or internal remedies, it will make short shrift of that point. But at least by not carving the case up, it will preserve the possibility that the SCA will decide the matter on the terms it sees fit. And then lastly, Judge, my lord and my lady, just while I'm on my feet, just on internal remedies, you know we've in our heads of argument said that we believe there's prospects of success there. I don't want to repeat the argument that we advanced in the merits twice, and now...
Please don't.
Yes. All I'll say on leave to appeal when it comes to public interest, because there's a temptation to think that internal remedies is not a public interest, is not an issue in the public interest because the law is settled and it all turns on the facts. I would just simply say that in this case, part of what the court found when it said that there was the internal remedies did not need to be exhausted is that the minister was in essence biased against the applicants in the Twitter posts that he put on. And we would say that with respect, that does change the dynamics slightly and does show that there is an element of public interest even in the internal remedies point, because that is a serious finding. And it would be, in our respectful submission, appropriate for that to form part of what's before the SCA if leave is to be granted on the other issues too.
The minister doesn't rely on that ground.
No, he doesn't seem to. No, with respect, that is so. We are taking the point, but yes, he doesn't seem to. And just lastly, if I could just clarify our position, we, on the cross appeals, we don't oppose anymore well, in fact, we never did say that we think that the cross appeal shouldn't be granted. We accept that it's a matter in the public interest. Just on the point that you asked my learned friend for the minister, that the Judge President asked on this question of not having to reach the declarator if the review was successful. With respect, that's an unassailable logic. If the review is successful, we agree that the court was correct, that it didn't have to decide the declarator. The only reason why we accept that the declarator issue should go on appeal is that, of course, we will be arguing in the SCA that the review shouldn't have succeeded. And of course, if the review doesn't succeed, well, then the declarator comes into play.
And we can't say that the applicants don't have prospects of success on that point. It's a very debatable law point. And so, of course, they have prospects. And so we would say, well, once we are going to be arguing that the review shouldn't succeed before the SCA, it's appropriate for them to be able to argue that they should have got their declarator. And so for that reason, we don't oppose the cross-appeal.
Thank you.
Those are my suggestions.
Thank you, Lord Malay.
We too do not oppose the application for conditional cross-appeal. And
that it is conditional.
it is conditional, and your Lordship, Judge President, made the point that in this court, when this court gave judgment, clearly it was not necessary to go to the declarators, having granted the relief relating to the review. As soon as we get to the SCA, of course, there is a prospect that the review finding is set aside, which then puts.
And so that's our
It is
position.
in that context that
Yes,
you
yes.
associate yourself with what was
Absolutely, that's correct. I'd like to deal with your leave with two matters. The one is the delay issue, and the other one is the consultation issue. And I'll deal with the consultation issue first. I have been in many cases in which the effectiveness of consultation has been debated, and you will see that very section in relation to exploration also arises, and in fact Maledu dealt with it in section 16 of the NPRDA, which is 16.4b. Also with Sanral, in this very community, when Sanral wanted to put a highway along the coastal road, the object being to spare members of that portion of the public from having to go inland for 5 kilometers, round a valley and back to a place. The question of consultation with the local community arose again, and in fact the same people who are in this matter, Mr. Zukulu, were in that matter. Now, what happens is that when you get to the Act, you see that 79.4a says you must consult in the prescribed manner, and Regulation 3 then tells you what the prescribed manner is. What happens is that...
Regulation, is it oh, sorry, you can continue.
Yes. So the regulation, that regulation is actually cited in the form it was in this court's judgment at page 26, and there you will see it all set out. Now, the position which this court took was not that there had been a breach of Regulation 3. What this court said was something slightly different. What it said is that the objects of Regulation 3 had been thwarted by the manner in which which impact, having been instructed by the regional manager, or Paja, which is the appropriate authority to engage in Regulation 3 consultations, had done it. So what that really means is that beyond Regulation 3, there is effectively unknown territory. And that unknown territory is informed by other provisions. The Constitution, perhaps Paja,
The regulations made in terms of
the regulations made in terms of Paja. But it is uncharted territory. And the difficulty is this, and why I raise it in this form is the following. From the point of both the people who have to undertake the consultation and the people who, and the regulator who says, I am satisfied with your consultation, I grant you your right. It can never be perfect. There will always be people and perhaps even communities that were not properly consulted, because these are complicated things, and what the public is and what the communities are also complicated concepts. Which community must be consulted, and can a particular community say, but you didn't consult me because I have particular requirements? So what the court did in this matter, and what courts often do, is that they say whatever is required, you didn't go far enough. And this is the very unhappy message that people like Impact and other companies who do some of the things often get. Where it raises questions of public importance is that this court then extended the territory beyond Regulation 3. They didn't put an end to it. And it is important, it is vital in the balance between development and protecting the environment. Because you can't have development which destroys the very environment upon which it relies, but you can't have environmentalists saying there can be no development, because in that case we must stop shipping coming in, we must stop motor cars, we must actually go back to a stage where people made their own food and they sewed their own clothes. So there is this balance. And what the court did, it then said, I believe it goes this far. It would be, and other courts will find we're not bound by this court's decision in other provinces, but would regard it as highly persuasive, obviously, may come to different conclusions. So we will, if that goes to the Supreme Court of Appeal, and it may go further, it may go to the Constitutional Court, it is in fact likely that it'll end up there, because this is this sort of thing is the very focus of that court, that balance. We would be saying, but for the sake of certainty, so that people know what they must do and they don't keep repeating the same mistakes, because if Impact were to do it again, they could do exactly what this court has suggested, and still another court would say, but you see, you should have called meetings in the rural areas where people do not have access to town halls or whatever it was, and that's what you should have done. Or you should have gone door to door. So certainty and guidance is what both the regulator and people like Impact would want. And that is why we say that even if you conclude that on that issue there isn't a reasonable possibility that another court will find differently, it engages deeply questions of the public and future guidance.
Yes. Mr. Loxton, at paragraph 95 of the impugned judgment.
Yeah, this is not an impugned judgment.
I'm using that.
Oh no, that's...
Paragraph 95, the second sentence, I think, it says, moreover, and in any event, the Constitution, Paja, MPRDA, and the regulations apply contemporaneously to the impugned consultation process. Would that be your point of departure in everything that you've said, which I believe is very important?
Yes. So
you accept that you should blend those in order to give effect to what the intention of the legislature was in enacting Regulation 3.
from an interpreter's point. is a matter where we would say it would be counterproductive for us to venture into the next round to reapply and then they presto, we'll go back again. So those are my submissions on the question of consultation.
Yes, before you tend to deal with something else, the other attractive argument that you advanced has to do with reaching out to the communities. And South Africa has got a situation where you have 11 official languages. As a matter of logic, one would expect, for instance, if you want to reach out to Xhosa-speaking people, you know what to do, even within the confines of Regulation 3. Is that not the position? I'm just saying, as a matter of logic.
It is true. And Lord, there's a line to be drawn. Court could say you could have done better. You know those report cards you get at school? Peter could have done better.
Yes.
But the task is not, of the court is not really to tell the decision maker it could have been better done. Now, no doubt, in retrospect, if you look at it, it's whether the failure is so material that you want to say, I am undoing this. Start again. And so that's the dividing line.
Would you say it's a could have done better situation?
Yes.
Where I say, as a matter of logic, we want to reach out to pay these speaking people, then you should know what to do.
I think, quite honestly, in retrospect, and
within
we go in 2013,
yes,
things change. We don't realize how much things change in nearly 10 years. But our appreciation of what is required, the cases that are being dealt with in the meantime, means that there's a mind shift. And the temptation is, because it's actually unconscious, is to look at the past through the lens of the present. So going back to 2013, you would still say, look, even then you could have done better. But the question would be, should the court intervene and say to the decision maker, start again? And that's my point. I don't think anybody would say it couldn't have been done better. Now, my Lord, the question of delay really goes like this. This court, when it was looking at knowledge, when knowledge of the grant of the right as opposed to the actual survey came to the knowledge of whose knowledge it had to come to, when did the clock start ticking? And you got the debate, and I don't want to repeat it because what I want to do is to take you to some of the answers that the respondents have given to what we raised, that it's not, it's a section 4 which deals with the public, which does not require notice, as you can imagine, does not require notice to each member of the public. It requires simply adequate publication, adequate processes. And Section 6 of the NPRDA doesn't take it any further because Section 6 is in two parts. The first part says any process must be reasonable, fair, etc., etc. But there just mirrors Paja, and in fact quotes Paja. So you don't advance things by jumping onto Section 6. What happens is this court looks at outer. It says, here is a problem, because there's no evidence really before me of the public. And this was a problem which came up in that Mastered NO matter, which is post-Paja, and they had to decide whether or not the setting side of a regulation engaged Paja, and if so, what do they do about delay? And they decided that the delay was so great, which was a few years, and it was not as great as this, which is a lot more that they were time barred. Now, what is the response? So you've got section 3, you've got section 4. This court said, I understand Paja, I read Paja, this is what Paja says, but I escape Paja because of section 3, which requires notice to the person.
Because of section?
It requires notice to the individual, it requires reasons, and you didn't give it, therefore we go out. Outer also was subject to the Paja scrutiny. They had exactly the same thing. They didn't invoke section 3, which they could have invoked to escape the problem of the time bar under Paja. So they were not in a different position to this court, and it was not argued and it was not, the court didn't accept that section 3 of Paja actually let them off the hook in terms of the 180 days. Now, what are the answers to that? The answers of the first to 7th respondents is intriguing, as one would expect it to be. And what they essentially say, was set out in their heads at paragraph 8 and following, and this is what they say, page 4. They start off by saying, we contend that it affects the public at large, so section 3 is misquoted. They say it's not correct. While it's true that the harm arising from a seismic survey would be felt broadly, the applicants include specific groups of individuals whose particular rights are adversely affected by seismic survey. And then they speak of the Gqeberha community,
yes,
and rights distinct from the public at large. So now they make an argument which is clearly something that this court didn't consider. That argument was not raised as far as I can see, and I'm a newcomer, and the size of the papers are truly daunting. So anybody who comes to this new takes a deep breath before going on. But what they're saying is public. When you talk about public and you're a community, you actually fall under section 3 and not section 4. So it's a new argument. We think it's wrong, but staying along the line of, is this a matter of great public importance? This would be an opportunity for the SCA to say, right, here was the debate. Take outer, take master NO, take this case, take section 3, take section 4. When is section 4 engaged? When is section 3 engaged?
But is there anything that precludes this court from upholding, assuming in your favor that it is new, and I'm not saying it is. Is there anything precluding this court from giving effect to that argument at this very point?
Well, giving effect to it would mean excluding, as I understand your Lordship, because your Lordship, this court has already made its decision on delay. But the question is, and I'm staying on the line of other compelling reasons. So it may turn out that you're absolutely correct. SCA is going to say, ready, they had it right. But it is a question because the 1st to 7th respondents don't respond by saying, no, clearly, outer isn't engaged because of section 3. What they say is, but section 3 applies because we're not the public. So, intriguing argument, something which this court did not consider, and something which we say in line with the rest of the judgment, the SCA should consider. And we go back to what was argued for Shell. It is quite clear that this court has the power to decide what goes to the SCA, irrespective of any view. Of course, this court would have regard to what the legal representatives of parties field, the lead, because after all, they're the ones making the argument to the court. The danger when the main line of reasoning and where the agreement was that this bundle of facts and arguments should go to the SCA. To carve out some may just lead to delay, because as you know, the Shell and Impact feel strongly about the delay point. So if we don't get leave from this court, there will probably be a petition, and that will lead to a delay, which is the only way we can expand what this court does, because it's inadvisable to go to the SCA and simply argue it and hope they don't knock you on the head and say, well, how dare you argue what this court has concluded. So that was the first to seventh. The seventh and eighth had other arguments, but their argument is almost along the same lines, and I'm going to summarize it because the court will know it's all in their heads. They say once their members had registered as interested and affected persons, they were transformed. I'm not sure how legally the transformation takes place, but anyway, they were the public. Then they registered. Now they have individual rights as registered IMPs, and they become individuals. And then whereas Section 4 would have applied, Section 3 now applies. It's a bit of a magical transformation, but there it is. It's again another interesting argument. We don't agree with it because it's not how individuals respond to the administrative action. It's the effect of the administrative action at the time it takes place. So when you characterize administrative action, that's the point at which you do it. You don't look at what happens after it. Lord, I think, Milady, I think I've now exhausted my time and probably your patience. And so unless there are
Thank you for the submissions you've made.
Thanks.
Yes, Mr. Gqeberha.
Thank you, Judge President. Good evening to the court, my learned friend, for the first to seven applicants. I agreed that I should go first. Justices, may I start with an overarching submission about the law which applies, given the agreement between the parties, that the appeal raises issues of public importance generally and in relation to particular grounds of review. We stand by that agreement, and I don't intend to depart from it. However, what we do say is that it doesn't follow from that agreement, and it doesn't follow from even this court finding that there are issues of public importance raised, that the merits of those issues fall away.
Yes.
If I can just give the court the reference to the SCA judgment, which makes clear that the merits remain important to deciding whether leave should be granted on that alternative ground. The most prominent decision is Karat Co, the Independent Advisory Pty Limited. The reference is 2020 Volume 5, SA 35. It's a decision of the SCA. And it says at paragraph 2, in order to be granted leave to appeal in terms of section 17(1)(a)(1) and 1(a)(2) of the Superior Courts Act, an applicant for leave must satisfy the court that the appeal would have a reasonable prospect of success, or that there is some other compelling reason why the appeal should be heard. If the court is unpersuaded of the prospects of success, it must still inquire into whether there is a compelling reason to entertain the appeal. And here comes the important part. A compelling reason includes an important question of law or a discrete issue of public importance that will have an effect on future disputes, but here too, the merits remain vitally important and are often decisive. In other words, what the SCA is saying is that even if it's not good enough to say here's an important issue, the merits of the publicly important point which are raised remain relevant to the question of whether it is a point in respect of which leave which should be granted. And so we say
if this court were to find, for example, to take the most hopeless of the points which our learned friends seek to advance, in relation to internal remedy, that it is an utterly hopeless point, then we say that in light of Carrot Co., notwithstanding the agreement that there are issues of public importance, this court could carve that out of whatever leave to appeal it grants to the SCA. Judge President, if I may move on to the question of delay, we say in relation to the question of unreasonable delay, it is also a point in respect of which on the common cause facts there are no prospects of success, and in respect of which leave should not be granted. We say that for the following reasons. It's true that in this case there was a long time period in between the date on which the decision was made to grant the prospecting right and the review application being brought. But there was no delay between the date on which notice of that decision was given to anyone, the general public or the interested and affected parties, and the bringing of the review. That happened at the end of November 2021. We know in this matter there was a long process which led up to the application in respect of which people registered as interested and affected parties. Those people were not, it is common cause, given notice that a right had been granted at any time. And there was no factual dispute about this.
And the judgment that we are about to take does deal with that.
Yes, in paragraph 66. That's the relevant paragraph, Judge President. So this interesting legal debate about whether we're under Section 3, which deals with individuals affected by administrative action, or Section 4, where the general public is affected, makes no difference on the facts of this case, because we say that on the common cause facts, the general public could only reasonably have been expected to come to know that a right had been granted at exactly the same time that everyone else did. In other words, the end of November 2021. And it's very interesting that the sort of marquee cases in our learned friend's argument to the contrary are, number one, Outer, and number two, Mostert. We would commend those cases to this court, because those deal with the instance where an administrative decision affects the general public at large, and they reach factual conclusions about when the public at large could have reasonably been expected to know about those decisions. In Outer, the Outer decision of the SCA is rich in factual findings about the extent to which the decision makers went to notify and publicize that decision. If one looks at paragraphs 10, 12, 15, 27, 28, the SCA sets out that there were media briefings, there were ministers' addresses, there was a cabinet launch, there were public hearings conducted, advertising to the public at large that these roads are about to be declared as toll roads. You must be aware we're going to take this decision. Once the decisions had been taken, there was a publicity campaign that was advanced. And so the SCA held, you were part of the broader public. You ought reasonably to have known some 4 or 5 years ago that these decisions had been taken, and so you are out for unreasonable delay. Mostert 2 is an instructive case because it deals with the challenge to regulations which were promulgated, and the critical finding in that case is, who do we say are the public at large? Do we mean Nick Ferreira in the street? Is he expected to know about pension funds regulations? And the SCA said, no, we're not talking about the average Joe. We're talking about people who are active participants in that industry, and they could have been expected to know before. Well, here again, those facts favor my side, not the applicants for leave to appeal side, because what we know is that all these specialist entities and people who have had a specific interest in this right went and put their hands up, registered as interested and affected parties, effectively said, I have an interest in this application, please keep me informed as to what happens. And we know that not even those specialists with particular interest were ever told that the right had been granted. So we say whether the interesting debate about Section 3 or Section 4, whichever way it cuts, it makes no difference to this court's order, this court's finding that there was no unreasonable delay, and so makes no difference to the order that this court granted. And so we submit leave should be refused on that issue. Justices, just briefly on internal remedy. The internal remedy point is only sought to be pursued by Shell. It is not a ground of leave to appeal advanced by Impact, and critically, it is not sought to be advanced by the Minister. Now, we submit in respect of a ground of appeal of this nature, that has a profound consequence, because this court made a factual finding that there was a reasonable apprehension that the Minister was biased and that he therefore could not fairly have sat as the internal appeal authority in considering any appeal against this grant. And the very litigant against whom that factual finding of a reasonable apprehension of bias is made accepts that finding. He says, very well, I don't seek to advance that in the Court of Appeal. Now, on the authority of bus... There's no evidence on record from Minister Mantashe in the main application. The point is not, the court will recall, squarely addressed in the answering affidavit filed on behalf of the Minister. And so, on the facts, the finding of a reasonable apprehension of bias we submit is utterly unassailable. And we would just refer the court to the consequence of that finding of fact for the upholding of this court, of my client's application for exemption from the duty to exhaust leave to appeal. The most pertinent case is Basson versus Hugo. It's 2018, Volume 3, SA 46, a decision of the SCA at paragraphs 22 to 27. And what the SCA held there was, it was a case where Mr. Voter Basson had been knocked out in the High Court for failing to avail himself of an internal remedy. Well, he hadn't been knocked out. The High Court found that the people who were going to sit on that panel had been justifiably found to be biased against Mr. Voter Basson, and that if they had purported to sit as an internal appeal panel, the process would have been a nullity, and therefore the duty to exhaust internal remedies did not arise, and manifestly an exemption ought to have been granted in terms of Section 7. So we say that the case is on all fours with the Basson case. Our learned friend didn't even address the point that where a court grants exemption in terms of Section 7C of Paja, it is exercising a true discretion. He would have to persuade you that there was some kind of material misdirection of law or fact to justify granting leave in respect of that order, and he didn't even attempt to do that. So we say in respect of that point, we say it's truly, truly hopeless. It doesn't raise any issue of public importance.
Hence you said it should be carved
It should be carved. Indeed. Justices, I've made my submissions on the merits of the appeal. We haven't addressed the consultation point because that point was really advanced by the other applicants, and so I won't rehearse or attempt to make any submissions on that. We do stand by what we said in the heads in relation to the Coastal Management and Climate Change Act, but there we do accept that this court's findings were res nova, and that there are interesting and important issues which the SCA ought to consider. On the cross appeal, it seems everyone agrees that there are prospects and that it's an important issue. Just to clarify, our position is the same as that which Mr. Loxton and Mr. Friedman adopted, which is, and Mr. Baileyfeld, which is that it's conditional. And so we don't say this court erred in the judgment it granted, but once it's up for grabs that the review relief might be overturned, then we submit that the declarator must come into play. Thank you, Judge President. Those are my
Thank you, Judge President. Justices, I intend in my brief submissions this morning to deal with three issues quite briefly.
Yes.
The first being whether there was any delay approaching this court with the review application. The second being the exhaustion of internal remedies, and that I will simply touch on, given that my learned friend has addressed that point before.
You've got new dimensions when it comes to that. There are new dimensions that you want to bring to our attention.
Indeed, Judge President, indeed. And the third point, Justices, is the question of consultation. Now, these justices are against the backdrop of the first to seventh applicants' acknowledgement that the issues raised in this matter are issues of public importance, but we did not concede that the applicants for leave to appeal or the respondents in the main proceedings carry any prospects that another court would reasonably come to a different conclusion. And it's against that backdrop that I wish to address you this morning. On the issue of the alleged delay in approaching this court, Justices, there are two issues that I would like to address you on briefly. The first is that distinction that they seek to, or that they draw between Section 3 and Section 4 of Paja. And the second is the issue with which Shell persists in relation to the fourth applicant's alleged knowledge of the seismic survey in April 2021. Justices, the first being the distinction between Section 3 and Section 4 of Paja, it's necessary for me to state what appears to be an obvious point, but it is one that is necessary to inform the rest of the argument. And that is that the distinction between Section 3 and Section 4 is not one about how many people are affected by a decision. The question is the manner in which they are affected by the decision and the appropriate provision to be relied on in a particular case is whether the proposed decision affects members of the public all equally, in which case Section 4 of Paja, affecting the public at large, is appropriate, or whether there exist any unique interests among individuals or groups that are worthy of protection and that are affected by the decision to be taken. And that is where Section 3 would apply. And so, Justices, it is not a question, as I said, of how many people are affected. It's not a question about whether individuals or groups are affected. It is a question of whether there exists something unique that is affected as opposed to something that affects the public at large. And the evidence before the court, Justices, is that the applicants were affected by the grant of the exploration right and the renewals of the exploration right in a manner that no other members of the public were affected. Now, the most obvious, Justices, is the issue that's been addressed in our heads of argument, and that is the question of the Gqeberha community and the customary fishing rights that have been acknowledged by the Supreme Court of Appeal. But beyond this, Justices, every one of the applicants has a unique interest that cannot be classified as an interest that is held by the public at large. Justices, this is dealt with, for example, at page 23 of the record in Mr. Zukulu's affidavit at paragraph 38. He states, "The land belongs to us, but we also belong to the land." And on page 24, at paragraphs 42 and following, he states clearly that the ocean is a part of the livelihoods of the applicant communities. It is a vital part of their diet. It contributes to the fact that the community has some of the lowest rates of hunger in South Africa, that the sea also provides the applicant communities with income. Further, at page 26, paragraph 48, he says, "Our livelihoods are not our only concern. The sea plays an important role in our cultural expression. It is sacred to us." I submit, Justices, that it is clear from this that the applicant communities, the first to seventh applicants, are not simply members of the public who have an interest in the decisions taken to award an exploration right or to renew that right. They have unique and specific interests that set them apart from other members of the public, that attract the procedural fairness obligations arising from Section 3 of Paja. It follows then, Justices, that the question of the delay is not one about when the public at large should have known about the decisions. It is about when these particular applicants should have known. And I will get to that shortly when I deal with the question of consultation. Before doing so, Justices, if I may just deal briefly with the knowledge on the part of the fourth applicant, which is an issue that has been pursued by Shell. Now, Shell relies on a statement in the affidavit deposed to by the fourth applicant, where they say he says he knew something in April 2021, and based on this, they suggest that all of the applicants are now precluded from approaching this court for review of the decisions. If I may, I would like to take the court to what he actually does say. His affidavit commences at page 296 of the record, and the relevant paragraph is at page 302, and it's paragraph 23 of his affidavit. He states, Justices, as follows. The Siklambeni community was not consulted about the exploration for oil and gas by Shell. It was only in April 2021, when I went to attend a meeting with the Green Connection, that I heard for the first time that Shell had a permit from our government, obtained in 2013, to conduct seismic surveys for gas and oil. I'm not aware that any of the other members of the community cooperatives, our village headman or chief, have been consulted at any point about the seismic surveys. And this is used, Justices, to suggest that all of the applicants are barred from approaching this court for relief. At the very best for Shell, Justices, what this amounts to is a single individual saying that he was aware of the existence of a permit. It amounts to nothing more than that. There is a tenuous link at best to actual knowledge of what the seismic survey would entail and the manner in which it would affect the fourth applicant's interests. But even so, Justices, even if the court was to find, or if a court was to find, that this meant that the fourth applicant had knowledge as far back as April 2021, this knowledge cannot be imputed to any of the other applicants and the communities in which they reside. Moreover, Justices, even if it was the case, this is not the delay of many, many years that the respondents seek to paint a picture of before this court. At the very best for them, Justices, this is a delay of 9 months in approaching this court. And I would submit that it is justified in the circumstances in the event that it would need to be condoned. In the circumstances, Justices, I submit with respect...
Well, of course, condonation doesn't arise.
Indeed.
We didn't have to get it.
Indeed, Judge President. My submission is that it would not be necessary to get to condonation, and that with respect, this court correctly found that condonation would not arise.
We did not even have to exercise our discretion. Well, going for the second leg, for instance, we only found that there was no delay at all.
Indeed, Judge President.
We didn't have to go for the second phase.
Indeed, and the reason for that was that, on the facts, the applicants did not know, the first to seventh applicants did not know before November 2021. Moving on then, Justices, to the point about consultation. And that is something that is directly interlinked to the question of the delay. Now, the real issue on consultation is the import of Regulation 3. And that approaches that have been adopted by the applicants on the one hand and the respondents on the other boil down to the following. Either we treat Regulation 3 as a mechanical checklist, or we make reference to Regulation 3 and we use it to inform whether there was a meaningful consultation on the manner in which the decisions would affect the applicants and their interests. Justices, we dealt in detail when we were here before the court on the last occasion with the decision in Gqeberha and the recognition in that decision that engagement in good faith in an attempt to reach accommodation is what is required by the MPRDA. I don't seek to traverse that again. What it means, Justices, is that consultation is not there simply for consultation's sake. It is there to ensure meaningful engagement, and this was recognized by this court at paragraph 95 of its judgment. Now, my learned friend for Impact has stated that, sure, Impact could have done better, and that there will always be people who were not consulted in the process. justices might I just remind the court of the people who were not, in fact, consulted in the process. The people who were not consulted are the holders of customary fishing rights. They are people who rely on the ocean for their food. They are people who rely on the ocean for their livelihoods and for their economic support. And they are people who rely on the ocean as a fundamental expression of their spiritual and cultural beliefs. And so the recognition there, justices, that there will always be people who are not consulted cannot, I submit, persuade any court that consultation in this instance was adequate. What Shell does in relation to the arguments or in relation to the principles set out in Begwanyama is to distinguish this matter from Begwanyama on two grounds. The first ground, justices, is that distinction between the processes in Section 3 and Section 4 of Paja. And they say that because this was a decision that affected the public at large, Begwanyama does not apply. Justices, I've addressed you earlier, and we have addressed in our heads of argument why this is incorrect, why the court was, with respect, entirely correct in treating this as a matter that attracted the obligations arising from Section 3 of Paja. There are unique and specific interests worthy of protection. And so this ground of distinction from Begwanyama must fall away. The second ground of distinction that Shell relies on is that Begwanyama relates to the rights of landowners. Justices, this too, I submit, is not a valid ground of distinction. It is not the actual content of the right that is relevant. It is the fact that there are rights and interests that are affected. And whether it's the right of a landowner, the right of somebody who relies on the ocean for their food, their livelihood, their spiritual and cultural beliefs, the meaningful consultation obligations are the same. Justices, this provides the lens for the consultation obligations that arise, including the consultation obligations arising from Regulation 3. Now, we heard from our learned friend from the Minister that there is no meat on the bone of Regulation 3. Justices, with the greatest of respect, that is entirely correct. The meat on the bone will be determined by the individual circumstances of each case. And in order to illustrate this, justices, one need only look at the observed results that would arise by a mechanical application of a checklist of Regulation 3. It requires that a notice be published in 2 languages. Would it be sufficient consultation if those languages were Spanish and Greek? It requires publication in a local newspaper or a national newspaper. What about the local newspaper of Timbuktu? What is required, justices, is a substantive engagement as to whether those people whose rights are affected could reasonably have been expected to know. In support of this, justices, I'd like to refer you briefly to a case that is not mentioned in our heads of argument, and it arises in a different context, in the labour context, but I submit that it is still of application here. It's the case of Strauss and Another versus Plessy Pty Limited. It's a 2002 decision, volume 23.
Volume
23. The Industrial Law Journal at page 175. And it's a decision of the Labour Court. That case, justices, arose in the context of engagements in the course of a retrenchment by an employer. As you would know, retrenchment is also a process that requires consultation with affected parties. And the court there criticized the employer for simply going through the motions of consultation and applying a formal process without actually ensuring that there was a genuine engagement and genuine agreement reached with employees. I would submit, justices, that the principles that are set out in that case are applicable here. This is not a case of simply going through the motions. It is a case of ensuring that those fundamental interests that the applicant communities hold are not unduly affected without the opportunity for them to make any input. Lastly, Justices, the critique against the 1st to 7th applicants is that they haven't challenged the constitutional validity of Regulation 3. But I would submit, Justices, that this is not necessary. Regulation 3 is not a rule book, as contended for by Shell in its heads of argument. It is a list of requirements which are applied in each particular context to guide whether there has been meaningful consultation. And again, at the risk of repeating myself, it is not something to be mechanically applied. The attack by the applicants is on the manner of its application. It is not on the content of the regulation itself. Justices, just finally, my learned friend for Impact suggested that the question in relation to the unique and specific rights of the applicants, and particularly those of the Gqeberha community, was a new argument that had been raised. If I may just refer you to paragraph 39 of the heads of argument filed in the main proceedings. The argument is dealt with there. For these reasons, Justices, I submit that there is no reasonable prospect that another court would come to a different conclusion on these issues. Thank you.
Thank you.
Thank you.
Thank you.
Well, I'll be brief. I propose two issues raised by my learned friend, Mr. Gqeberha. One is the reference to the Supreme Court of Appeal decision he referred to relating to merits playing an important function in determining whether leave should be granted or not. The Zuma decision I've referred to, of course, if one reads it objectively, what it says seems to deviate slightly from that, because in the Zuma decision in paragraph 3, it seems to distinguish between matters of general importance as a generic term and more specific matters of general importance which relates to the interpretation of a statute. Because the wording in Zuma is that inasmuch as the appeal raises a point of statutory interpretation, the application has to succeed. That slight distinction has recently been raised in this division by His Lordship Mr. Justice Lowe in an application for leave to appeal. Perhaps I should give Your Lordship the reference. It's a matter Sotsozi, S-O-T-S-H-O-Z-I versus DeWitt and others. Z-A-E-C-G-H-C 103, dated 25th of November 2021.
Can you repeat that? Z-A something?
My own junior has just handed me 2 copies, if I might just hand them out. But just for the Safely reference, it's Z-A-E-C-G-H-C 103. And it's a very short judgment, but if Your Lordship and the Lordship will read it, what His Lordship Mr. Justice Lowe effectively says is that, well, I've now alerted the parties to the Zuma decision, and he quite correctly, as argued by Mr. Ferreira, refers to the standard law relating to merits, and he refers to a previous SCA decision, the Minister of Justice and Constitutional Development in Southern Africa, a judgment by Justice Wallace, where he quotes that paragraph where it says, that is not to say that merely because the High Court determines an issue of public importance, it must grant leave, the merits of the appeal remain vitally important. But then he seems to distinguish the Zuma decision, and he says, well, this might add a different dimension. And then he concludes that being so, it seems to me that whilst I'm not much persuaded that there is a reasonable prospect from the 2 issues which I decided, nevertheless, it cannot be denied that it is not, that not only is this a question of interpretation, etc., in public report. So that is the one issue. The other issue is perhaps more en passant, and that is the mention that the minister didn't become involved in the issue relating to internal appeal. perhaps the answer lies here in the Lord and my lady, is that the situation is possibly similar or comparable to a situation where a administrative tribunal or organ or even a judicial officer is asked to recuse himself not because there is bias, but because of a perception of bias. And it's probably prudent for the minister not to have got involved with that issue at all. And then lastly, and this is really just a throwaway comment, our learned friend for the 1st to 7th respondent in debating with your lordship and your ladyship the publication in the language, I think it was more tongue-in-cheek than anything else to suggest that it would be all right to publish in the Spanish language in the area. Of course, the regulation wouldn't make provision for that, because on a proper reading of Regulation 3.4, it would have to be a circulating newspaper in the area, and I doubt very much within that area there's a Spanish.
I suppose it was just a manner.
Yes, no, I understand. Of course, in conclusion, there's one issue which none of the parties have dealt with, but of course that's the question of cost. We simply say that in the event of leave being granted, well, the usual order of cost should follow. But of course, we must concede that if your lordship and ladyship is against leave, well, then the opposite would apply. Yeah. As your lordship.
You've got anything, Mr. Freedom?
Very brief also, my lord, less than 3 minutes. Just also, if I could just make comment with my learned friend on the issue of costs, we would say the same as my learned friend from the minister. We would say that we take the same position. Just 2 points on this delay, just on the prospects of success. These arise from my learned friend for the 1st to 7th applicant submissions. She read out extracts from the affidavits of some of her clients in relation to their connection with the sea. We would simply just reiterate that there is a reasonable prospect that the SCA will look at the question of delay and look at the outer test and say that this is a case where the public that is affected at large rather than the individuals. We simply say that because it's not a subjective test with respect. So it would have been possible in the outer case, for example, for various members of the community to put up affidavits to explain how the e-tolls would have affected them personally. That doesn't transform it into a case that affects the public from a case that affects the public at large into a case that affects individuals. Because of course every individual can show on a subjective test that they are affected by administrative action. An objective test to determine what the widespread effect of the administrative action is. We submit that there is an indeterminate class, especially from the perspective of the parties arranging the consultation process. And so in other words, it couldn't have been known in advance precisely who says that they were affected and in what way. That's going to be a relevant factor to the argument for delay, because it's going to be relevant to the question of whether this is a public at large case or an individual affected under Section 3 of Paja case. And we submit that there's at least a reasonable prospect that the SCA would consider this to be a similar case to the outer case, for all of the reasons that we've submitted in our heads of argument. And then just briefly on this Regulation 3, my learned friend submitted that it's not a rule book, that it's rather a guide. The fact of the matter, though, is that it seems now to be common cause, at least a guide to impact when it did the application. And we again reiterate our point about fairness, which is that to apply it retrospectively in these circumstances is unfair. At the time that the regulation was enforced, and at the time, which is almost 10 years ago, that the consultation began, impact considered itself to be following what was required of the law at the time. And that's the purpose of regulation. If we can take the attitude that the regulations are there, but they're just a guide, and nobody has to really necessarily comply with them because a completely separate test might be applicable, well, that gives rise to uncertainty, which in itself gives rise to unfairness. So we persist in submitting that the only way to advance the arguments that were advanced would have been to attack the constitutionality of Regulation 3. And so we persist in saying that there are prospects of success on delay. And very, very lastly, I'm not entirely clear about my learned friends from the applicants on all sides submissions, because on the one side hand they agreed on Friday that all of the matters raise issues in the public interest, but now I'm not entirely clear whether they're arguing that no leave should be granted or some leave should be granted. Certainly my learned friend for the 9th respondent does take the view that on internal remedies there's no prospects and there's no public interest, despite having reached that agreement with us on Friday, which didn't carve out any issues.
But again, then I will just simply reiterate that the submission I made before is we don't believe it would be appropriate to bind the SCA by saying some issues are good, some issues are bad for determination. Once leave has been granted, and once the cross appeal leave has been granted in the cross appeal, we would submit it would be appropriate for it to be on all issues, just so that the SCA can decide what's best. And also I would make common cause with what my learned friend for Impact said. It will just create unnecessary procedural difficulties to carve out. It makes the work of this court harder, it makes the work of the SCA harder. If there's half the matters are before it and then the other half have to come before it by petition, we would just respectfully submit the cleanest way is for leave to appeal to be granted on all issues.
Mr. Lux.
Thank you. Well, there was an interesting development in the arguments. But, the first is, what is the test then, where the decision sought to be taken on appeal raises public interests of such a nature that there are other compelling reasons, but there is doubt as to the merits of the appeal. Now, learned friend Mr. Ferreira said that you would not grant leave, from citing Carrot Co., you would not grant leave to appeal if the merits were utterly hopeless. He gets that from that case because although that case in fact doesn't deal with the test, it sets out the public law interest, in other words, other compelling reasons, it sets out the merits. And then at the end it says that the merits are utterly hopeless and there's therefore no other compelling reason. So although not expressly dealt with, that's the conclusion it comes to. Then in the Sochozi case, which the learned friend from the minister referred to, in that case what happened was that there was a decision finding by the learned judge that the merits were poor. He was not persuaded about the merits and yet granted leave to appeal on the basis that it was an interpretative issue, important, other compelling reasons. So in the interplay between the one and the other, it is incorrect to say broadly that in deciding whether to grant leave where there is a public interest sufficiently strong to merit other compelling reasons, you would be entitled to refuse leave because you were not persuaded about the merits. The true position and the true approach would be you would only refuse leave if you found that the merits were utterly hopeless. Because if they are utterly hopeless, well then there's no compelling reason because it's just simply never going to go anywhere. So the test is completely different when you're looking at that section of the Act. And then you come to an intriguing aspect of the submissions made to you by all of the applicants, raised by my learned friend Michelle, and it's this. When agreeing that the matter should go on appeal for other compelling reasons, they obviously did not believe that the merits were so poor on any of the issues that this court ought not to grant leave. So it is somewhat surprising to hear submissions that although they have agreed that there should be leave to appeal because of other compelling reasons, public interest, nevertheless leave should not be granted because the merits are poor. So it seems to us that that is a recanting of the previous position. Now, to move beyond that, beyond the text, because that was the one important thing. One of the things that delay the argument about delay gives rise to, not addressed as far as I can see by any of the applicants, is this. When you become aware that there is an application for an exploration right, or a mining right, or anything else, which is going to affect you, you have
upon being notified.
Well, they are notified, so many of them are notified, they participate, they're notified that there is an application. The complaint is that they're not notified about the decision.
Yes.
So I'm taking step by step. And I'll come to the question of when they should have become aware. But it seems to me that what is missing so far here is what are the duties of somebody who becomes aware of an application, the result of which may well be an outcome, administrative action, which will affect their rights. And I suggest to the court that they must be proactive. They cannot be supine, sit back and say, well, I'm just going to wait until somebody tells me. And in fact, that was investigated in Outer. Once you are interested in the process, you must actually inform yourself. So everybody who was aware of the application had a duty to inform themselves about the progress of the application. And they can't simply lie back and say, I wasn't told of the decision. Now I'm going to come to those who say, I wasn't informed about anything. Not the application, not the result of the application, not anything else. Remember what the contentions of the applicants are. And that is that these seismic surveys have a profound effect on the environment. Fishing, cultural, economic, harm to the environment itself. So they're saying these things are obvious. It's so dramatic that you can see it. And yet we know there are three previous ones, 2013, 2018, the same effectively, 2D versus 3D, but it's the same effect. So if you accept their contention that these things have these dramatic effects, the probability that they must have become aware of an activity which should have led them down a path to say, why? What's happening here? That's a logic, simply a process of logic. So on the merits of this, the question which then arises is, well, can it be said that the delay issue is utterly hopeless? We would suggest that even if
I
this...
did not understand the argument to include the delay issue. I thought it related more to the one about internal remedies.
Yes. I say internal remedies, I do not have a dog in that fight. And that's fine. But for delay, which is and consultation, which we are very interested in, we say it cannot be said. It may be said, and it would be open to this court to say, as it was in the case that the learned friend for the minister said, I am not persuaded about the merits of this, but this is the test, and so on. And then finally, in relation to this whole idea of the community versus the public, I've had a look at the heads of argument in the main application for...
Would you mind if we took
not at all.
a short adjournment,
I will still be
so that we don't interrupt the flow of your argument?
I have
We need to confer with our
Yes.
colleagues on other administrative
Certainly.
issues. We'll be back soon.
Well,